This case starts the way so many eviction cases do, with frustration, fear, and a sense that something has spiraled out of control faster than anyone expected. A tenant who believed she had stability, a landlord who insists the rules were clear, and a courtroom where sympathy and legality don't always line up the same way. What you're about to watch isn't just a dispute over rent, it's a breakdown of expectations, communication, and the harsh reality of how landlord-tenant law actually works. Text messages, missed payments, verbal promises, and assumptions all collide here. And the most dangerous part, what wasn't written into the lease. As this hearing unfolds, pay close attention to the timeline when payments stopped, when notices were sent, and how quickly the court zeroes in on one central question. Because by the end of this case, one side walks away with possession, and the other walks away with nothing but days on the clock.
Kimberly Wenslake.
Your Honor, this is
I'm
Kimberly.
sorry? Yeah, hi.
I am messaging him, but I had contacted legal services. I was denied by all three because of my job.
Okay.
So I contacted a personal lawyer.
Yep.
And this was just last week. I finally got with him. I haven't been able to sit down with him, so we would like to adjourn today because I need to hire him, and I'm taking him on, but he needs to have more information on our case.
Your Honor, this is a simple landlord-tenant matter, and if she was, then I know Chuck myself, Your Honor, and I, as an officer of the court, well, I called and left a message on his cell. I didn't get through to him either. As you know, these are very time-sensitive matters, and if she, any attorney contacted last week would have contacted me,
I never planned on ever leaving
indicating
here. This was going to be
Hold on,
my
hold on.
primary residence. And I've been paying, I paid him, so I don't understand. This came out of nowhere, left field, through a
Ma'am.
text message.
Your Honor, this is not through text message. This was
Yes,
done
it
through
was.
the
We have all the
legal.
documents, Mr. Sabo. I have every document, so I would like to have more time, please, and sit down with Chuck and review and take him on as my attorney.
Ma'am, you've had since December 16th, though.
Yeah.
I've got no
Correct,
appearance.
but I was waiting for responses back from legal services. I just got it back, so then last week I contacted Chuck. Then I lost a friend, Abel Ruda. I dealt with his funeral, and I just got back with him like, hey, I'm so sorry. I have court. I called him yesterday. I have court tomorrow. What do I do? So if I could please get it adjourned and have more time to sit down with him, I am taking him on as my lawyer. Because
you can do that too, ma'am. But I guess for today, Mr. Sabo wants to proceed, and he's got a right to proceed today. We'll proceed, and if you get a hold of Mr. Destel, he wants to have a motion filed, we'll deal with it that way for you. Okay.
Okay, thank you.
Mr. Sabo, do you have a witness or?
Absolutely. Yeah, Mr. Bosley is here. Mr. Bosley, unmute, please.
Craig Bosley, Bosley.
Isn't it true you're the owner of 313 Myrtle Street, Flushing, Michigan, 48433?
Yes, I am.
All right. Isn't it true you entered into a lease with the defendant Kimberly Sin as...
This is an important moment, and one that happens all the time in eviction court. The tenant is asking for an adjournment to hire counsel, but the judge is balancing that request against how landlord-tenant cases are treated under the law. These matters are considered time-sensitive, especially when possession is at issue. Notice how the judge doesn't deny her the right to an attorney. Instead, the court allows the case to proceed today while leaving the door open for a future motion if counsel steps in. That distinction matters. It means the judge is following procedure, not making a personal judgment. And it also signals something else. The court is already focused on whether the landlord met the legal requirements, notice, service, and non-payment, not on future intentions or verbal discussions.
Sin as tenant.
Yes.
Isn't it true that was a month-to-month term as evidenced by your start date indicating July 31 and end date August 1, 2025?
Yes.
Correct. Isn't it true that there's no option to purchase contained in the lease?
Yes.
Isn't it true that you were not paid any money or consideration for an option to purchase?
That is correct. Yes.
Okay. And you sent out a notice to quit on November 5th, 2025 with a move out date of December 5th, 2025.
Yes.
And then the landlord-tenant complaint was filed on December 9th, and which included the lease, notice to quit, and non-military affidavit. Isn't that correct?
That is correct.
Right. And the complaint and attachment were served by attachment on December 12th, 2025. Isn't that true?
That is true.
Okay. Isn't it true that you've collected no rent for November through today's date?
That is correct.
All right. And you're seeking a possession-only judgment with an order to evict to be issued if defendant fails to vacate by January 16th, 2026.
That is correct.
Okay. And again, no money judgment at this time, correct?
No.
Thank you, Your Honor.
Okay, Ms. Wensley, you get a chance to ask questions of him as well. Do you have any questions for him?
For Mr. Bosley?
Yes.
No, Your Honor, I do not.
No? I think I do, Mr. Bosley, on the lease agreement that was filed with the court, there's a box under terms, month-to-month lease, but it's not checked. It says same.
Here's where the landlord's strategy becomes very clear. He is not seeking money, only possession. That's a deliberate legal choice. By removing money damages from the equation, the case becomes much cleaner and faster. The court doesn't have to untangle partial payments, late fees, or disputed balances. It only has to answer one question: does the landlord have the legal right to regain possession of the property? And based on the testimony so far, the landlord is establishing a straightforward chain month-to-month lease, no option to purchase, proper notice to quit, and no rent paid for multiple months. In eviction court, simplicity often wins. The fewer variables, the less discretion the judge has.
It says same as above. I'm not sure what that means. Same as above, January 31st, 2025. Open review 1 year for both parties.
Yes, Your Honor. May I speak to that?
Yes.
All right. Due to at the very beginning of the month-to-month lease, I tried working with Miss Sin associated to late payments. And I worked with her for a couple months, and part of the agreement was all the payments were supposed to due on the first of the month.
Okay.
And she had some difficulties in paying. She finally paid both September and October up in October. And I tried working with her through the difficulties that she had. And when she did not pay for November, that is when I served Miss Wensley due to non-payment of November 1st, even though she was aware that the payment was due.
Okay, I know Mr. Sabo had asked, I just want to make sure I understand. So, but you've received no payments from November of 2025, is that right? Today?
I have not received any payments since November, December, and January.
Okay, and so when the lease says that term, it's just the way.
Your Honor, can I ask you?
Sure,
Can I
sure,
mention?
go
So,
ahead. Yeah.
and I want to make sure that Mr. Bosley, that sentence, open review in 1 year for both parties, that's a note that you made, correct?
That is correct.
Okay, so that wasn't on that was the note, correct? That open review was not on the lease when it was signed, correct?
Yes, it was.
It was on you just highlighted it for me.
I highlighted it, correct.
Well, I'm sorry, highlight. Okay, there was a highlight on there, Your Honor. So I wasn't sure which was actually part
Yeah,
of
got-
part of it.
And
The part that-
if I may, Your Honor, due to only getting $1,000 a month, knowing that the rental, I could have gotten a lot more. The whole beginning of getting Kim into the property was try to help her out.
This exchange highlights a common and costly issue: unclear lease language. The tenant is focusing on phrases like open review and handwritten notes, believing they represent flexibility or future opportunity. The judge, however, is examining whether those notes actually change the legal nature of the lease. Initials matter, written terms matter, but expectations do not override payment obligations. Even if there was an understanding about future review, rent was still due on the first of every month. Courts look for enforceable promises, not implied hopes. This is where many tenants misunderstand their position, assuming goodwill or informal agreements carry legal weight. In most cases, they don't.
help her out and build credit. And she had hardship and she wasn't able to pay on the first of every month. And that led into October.
Your Honor,
Ma'am, I'll give you a chance to testify just a second, Jude. Let me just finish up with him real quick then. But I guess for my sake, Mr. Bosley, though, where you said it's just a no, it says open for both parties to be determined, TBD, but I've got initials by both of them. I've got
Yes,
your initials and I got her initials. It's not
yes,
really,
your
that
Honor,
doesn't look,
if I-
hold on, that
Yeah.
doesn't look to me like it's just a no. Looks like you both agreed to that.
No, we agreed to that on July 31st, on June when we signed.
Okay,
And I told her that in 6 months, I'm going to have to increase rent in the area. And that was not written, but she was aware of that. The property was never up for sale, and with her an option to buy, it was a month to month.
Mr. Bosley, I
Okay,
believe you did put paid a will review after 6 months.
Correct.
It's
yeah, and I
it's
did see
on there
that too. Yeah,
in number 4.
yeah,
And your Honor,
I did
again,
see
the
that
other
too.
part was in number 9. Again, you're going to see start date August 1 and the end date open. So,
Yeah, okay. Well,
So, I mean-
regardless, there's been no payment since
correct.
the one
Correct.
payment.
Correct.
That part is true. Whether I consider it a month to month or just a full year lease, you've received $1,000. Is that right?
A little bit more than $1,000.
no, we received 3 months, sir. 3 months.
That were
3
all
months.
late.
I was here 3 months.
They
He's
were
received
all
every
late.
payment I have except for the very first installment, because he said he was moving to Chicago and he already made the August rent payment, so he was gonna use that money to go to Chicago. So I brought him that payment, which was $750 in cash. That's the only installment that I don't have on the Venmo.
No,
And I
it was
I
all
keep
late
it back.
payments, Tim, and you know that.
But when we sat down, I said, you do have 15 days. I did have a mortgage before in case I'm in any trouble. You were very informed on my situation. I did not keep anything from you, Mr. Bosley.
No.
Okay, so,
So-
let me-
Your Honor, we do acknowledge
Hold on.
that August, September, October were paid. Just nothing
Yeah,
after.
He
Yeah.
sent me a message at the end of October, right before
okay,
November.
hold on, man. Before you do that, why don't you do this? Why don't you raise your right hand? Unless Mr. Sabo, do you have other questions for Mr. Bosley, I guess, first?
No, we're good. We're good.
Okay. Ma'am, why don't you raise your right hand there for, do you swear from the testimony you're about to give will be the truth?
And nothing but the truth, Your Honor.
Okay. So just for my sake, let me just get my question out because it'd be the easy part of it. Did you pay November of 2025 rent?
No, when he had
What
sent
about-
me, no, I
What
have
about
not.
this? Okay, so November or December, did you pay December's rent?
No, I owe him for them 2 months, Your Honor, and January now.
Okay, in January. So we got November,
That's
December, January that have not been, and I'm not saying that, I just want to make sure I know what has and has not been paid. So what else did you want to tell me?
I don't know. I have to calm down a minute because I cannot believe this is happening. He was very informed of my situation. I had lived in White Oak Estates before. My rent there was $1,200 a month. I paid it. I was fine. I had ran
This
into
is the turning point of the entire hearing. Once the tenant confirms that November, December, and January rent were not paid, the legal outcome narrows dramatically. Eviction court does not decide who is more sympathetic. It decides whether rent was paid and whether notice was proper. Even explanations involving escrow, confusion, or fairness typically don't stop a possession judgment unless backed by written agreements or proof of payment. At this moment, the judge now has uncontested testimony of non-payment across 3 months. Everything that follows is context, but the core legal question has effectively been answered.
I had ran into I'm just going to tell the whole story. I ran into Mr. Bosley. He was an old customer at Duffy's. I always thought he was a nice gentleman. Da, 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 da. He was always kind and everything to me. We all went in there one day and I was talking about how my rent was killing me with my car payment. And then he had been talking about how he was going to put his house on the market. We sat there for a while, and at the end of the conversation, he was like, well, why don't you rent out my house? And I said, well, Mr. Bosley, I'm not going to rent a house unless I'm going to rent to own it, or I'm looking to purchase a home, but I got to get my financial situation in order. So that was our conversation that day. I would say about a month goes on, my phone rings and it's Mr. Bosley, and he tells me, I'm taking my house off the market. I would like you and your girls to move in it. It's a great area, da da da. Come and check it out. We'll go over a contract. So I went and I did that. We signed the contract. Me and my daughters moved in here August 1st. I was here August. I was very honest with him about my financial situation. He was working with me. I have text messages. I have everything documented. Then I paid October. And then at the end of October, I knew I had to pay November. He constantly was on me about the payment. I've never had a landlord on me about that. From like the 28th of the end of each month, he was texting me. I know what I have to pay. I have a good job. I'm sorry, but I'm not a piece of crap. So, then at the end of October, I went to homecoming with my daughters. We got back here. I went and took them back to their dads because I work in the early morning, so he takes them to school. And I got a text message that I had 30 days to get out. He was putting the house back on the market. So I tried to call him and he did not answer. And then I messaged him like, what? So then I told him, okay, well, I'm holding until I figure out what I need to do. Like, what is going on? I'm holding your money. I'm not giving you another cent. I'm putting it into escrow until we get this figured out. I never planned on leaving this house. I planned on staying here. It's right around the kids' schools. And he knew that. The sit down and review in a year was to sit down and see where I was at with my finances and to go further, go on further of being able to purchase this house.
I don't see anything, ma'am, you gotta help me out a little bit. When you said rent to own, I don't see any language in this lease agreement that says it's a rent to own.
Right. He was smart on that, just saying it in words and not putting it down on paper. And that's where I fell for the okey doke.
Gotcha. Okay. All right. Mr. Sable, do you have any?
And you know,
questions for-
again, the crux of this is,
Well, I'm sorry, any questions for her though? Anything?
no questions at all.
Okay, okay.
No.
All right, you can go ahead and give me your argument now.
Yeah, just, at the end of the day, again, she had some financial issues. He was aware of that. That's why it was set up as
This is one of the most emotionally charged sections of the hearing. The tenant describes conversations, trust, and perceived promises, and you can hear the sense of betrayal in her voice. But notice how the judge gently redirects the focus back to the lease itself. Courts cannot enforce verbal assurances that aren't written into the contract. Rent-to-own carries specific legal meaning, and without that language in writing, the court cannot treat it as such. This is where emotion and law fully diverge. The story may feel unfair, but fairness and enforceability are not the same thing in court.
as a month to month. They were going to review it. She did not testify nor address or refute the fact that it's not a month to month, or provide any testimony or any evidence. This was a month to month lease. We're not seeking a money judgment. She has not paid any rent for November, December, January. We're simply seeking a possession judgment to be entered.
And I guess I got one question, Mr. Sable, maybe you can help me out with this one. That just, is there a security deposit still sitting there then? $1,000 security deposit?
No, he waived the
believe-
security deposit.
Oh, okay. So I just want to make sure that we don't have money sitting there for some reason.
No,
Sounds
I'm
like, okay, all
completely
right.
screwed.
Okay. All right. I've had a chance to review the lease agreement that I've asked questions about as well. Is somewhat inarticulate that the lease agreement is. Still find that there was a lease agreement that was whether it's deemed a term lease agreement for a year lease, or if it's a month to month, which has been argued as well. Because nonetheless, the payments were $1,000 per month, start on the first of each month, based on the totality of the testimony I've heard. At this point, November, December, and January's rent has failed to been paid. Grant judgment for plaintiff in this matter allow a writ of eviction after, how much time can you give her, Mr. Sabo, to move out? Is it-
We could,
you ask for
we
this-
could,
Go ahead.
10 day, but we could extend, Your Honor, a courtesy in this matter. Instead of the 16th, how about we push it 1 week, Your Honor, in
Okay,
addition.
So we did
So that's fair.
20 Okay, all right, so that'd be the 23rd, whatever
Yes.
date
Your
that
Honor, can
falls
I
on.
say something, please?
Sure,
Can I say something to Mr. Bosley?
yep. Wow, yeah, we're gonna watch it, but
Yeah, Your Honor, this
I
is a
was
slippery
just
slope here.
gonna say,
yeah,
You could have left me alone. I was extremely honest with you,
okay,
and you know exactly my situation. So now I have nowhere to go. And I
Uh,
hope you're very proud of yourself.
In Your Honor, I'll,
Yeah,
again,
The
Mike-
judge has now ruled for possession, but pay attention to the extension. This is judicial discretion in action. While the landlord is legally entitled to regain possession, the court still considers the human impact. Granting extra days isn't required, it's a courtesy. The extension to the 23rd gives the tenant a narrow window to relocate, apply elsewhere, or prepare for enforcement. And importantly, this is not a money judgment. That means no immediate wage garnishment or collection order, just the loss of possession. It's a small mercy, but it doesn't change the outcome.
I'll,
Yeah,
again, we'll
Mike-
extend, you're right,
Okay.
we'll extend it to the 23rd, Your Honor, which obviously will give her throughout the weekend. So practically speaking, it's 20 days, doubling.
yeah, that's fine.
Okay.
We'll do
Yep, and I'll
Janet's
get that
motion or whatever.
judgment submitted to Janet.
All right, sounds good.
Thank you very much, Your Honor.
Thank you, Sabo,
Bye.
Mr.
Bye.
Bosley, and Miss Wednesday stepped off.
Understood.
All right.
All right, thank you, Your Honor.
Yep, bye now. Miss Wednesday, thank you. We'll get judgment. We got till the 23rd though, and it's not a money judgment.
I've
So,
already tried to apply places. I don't know.
okay. Well, I'm sorry about that too. I don't like to do that either, but got to follow the rules for everybody, and that at least give you some time. Okay.
Yep.
All right. Bye now.
This case ultimately comes down to one undeniable fact. Rent was not paid for 3 consecutive months, and the lease did not include the protections the tenant believed it did. The court followed the law, notice was proper, non-payment was admitted, and possession was awarded. While the tenant's circumstances are undeniably difficult, eviction court operates on documentation, timelines, and compliance, not intent or hardship alone. This ruling reinforces a critical lesson for both tenants and landlords. If it's not in writing, it doesn't protect you. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.